3, 2, 1, start. The subject matter of challenge in the instant writ application is a disciplinary proceeding initiated against the petitioner through a charge sheet dated 30th May, 2008, issued by the respondent number 3, stop, para. The facts, in a nutshell, are that while working in the post of Assistant Security Commissioner, Railway Protection Force within bracket hereinafter referred to as RPF bracket close, the petitioner was transferred to Eastern Railway and was posted as an Assistant Security Commissioner, RPF, Passenger Security, Eastern Railway, Kolkata, stop. Subsequent thereto, the petitioner was served with a charge sheet dated 30th May, 2008, issued by the respondent number 3, proposing to hold inquiry under Rule 9 of the Railway Servants within bracket Discipline and Appeal bracket close rules within bracket hereinafter referred to as RSDA rules bracket close, stop. Prior thereto, when the petitioner was working in the post of inspector under RPF, within bracket small I, Koi Garden Reach, an order dated 25th July, 2002 was issued by the Chief Security Commissioner, RPF, SE Railway, transferring the control and supervision of the said RPF 1 Koi, Garden Reach to the Security Commissioner, RPF, SE Railways, stop. Such action was challenged by the petitioner through an application under Article 226 of the Constitution of India, being WP number 13909 within bracket W of 2002, and the said writ application was disposed of by an order dated 19th March, 2003, observing inter alia that so long the petitioner will remain in the post of 1 Koi, Garden Reach, the Security Commissioner, CBI, Garden Reach, namely, Sri B.B. Mishra will not be the disciplinary or controlling authority, and any action taken by the said B.B. Mishra against the petitioner would be subject to the approval of the Deputy Chief Security Commissioner, RPF, SE Railway, Garden Reach, stop, para. Records reveal that in the instant writ application, an interim order was passed on 7th April, 2009, restraining the respondents from proceeding against the petitioner in respect of the first 4 articles of charge until further orders or until 15th September, 2009, whichever is earlier, but liberty was granted to the respondents to proceed against the petitioner in respect of the 5th article of charge, in accordance with law, stop. The said interim order was directed to continue for a period of 6 weeks after the reopening of the court after the Puja vacation by an order dated 17 September, 2009, and the same accordingly expired sometimes in the month of December, 2009, stop, para. A perusal of the writ application reveals that the disciplinary proceeding was challenged, alleging inter alia that the respondent number 3 had no jurisdiction to initiate the disciplinary proceeding against a superior officer like the petitioner in the absence of modification of clause within bracket small b of Rule 3 within bracket 1 of the RSDA rules, stop. The said ground of challenge was turned down by the order dated 7th April, 2009, and upon a prima facie satisfaction to the effect that the charge of collusion was not sustainable as the respondents did not initiate any proceeding against the officers, namely, Mr. X and Mr. Y, an interim order was granted restraining the respondents from proceeding with the first 4 articles of charge, stop, para. Records further reveal that pursuant to the liberty granted by this court on 22nd January, 2013, the respondents filed a supplementary affidavit incorporating the documents to the effect that the disciplinary proceedings were initiated against the said Mr. X and Mr. Y, and in the said proceedings, the Chief Vigilance Commissioner recommended imposition of punishment against the said officers for having acted in collusion with the petitioner herein, but the final order of imposition of punishment is yet to be passed. Stop para. Mr. Mojumdar, learned senior counsel appearing for the petitioner, submits that the charges were still, having been framed against the petitioner more than 6 years after the alleged incident, and the said delay has also not been explained by the respondents, and on the said ground itself the charge sheet is liable to be set aside. Stop. In support of such contention, Mr. Mojumdar has relied upon the judgments delivered in the case of M.V. Bijlani versus Union of India, reported in 2006 5 SCC 88, and in the case of P.V. Mohadevan versus MDTN Housing Board, reported in 2005 6 SCC 636. Stop para. Mr. Mojumdar further submits that the disciplinary authority had always acted in the dictation of the higher authority, and such conduct would be explicit from the fact that even after the inquiry officer declared the petitioner not guilty in respect of the fifth charge by a report dated 13th January, 2010, the disciplinary authority, instead of concluding the said proceedings pertaining to the said charge, referred the same to the Director General, RPF, New Delhi for his advice and opinion. Stop.